Hello everyone, this is Dr. Madhuri, Associate Professor, Department of Law, SPMBB. Today we are going to discuss about another topic, that is Negotiable Instrument Act. NA Act 1881, which governs the operations, does too and without strict definition of NI Act, but it also states Section 13 of promissory notes, bill of exchange, checks which are payable either to order or to the bearer are called NIs. Main characteristics, if you want to talk, they are easily transferable. Transferability does not make any instrument for a negotiation or a negotiable. Example, share certificates of a company we can take. And Negotiable Instrument Act means the property in the negotiable instruments can be transferred by delivery of an instrument if it is a bearer, or by an endorsement, and delivery if it is on an order one. The title of a negotiable instruments can be transferable from transferor to the transferee. The transferee of a negotiable instrument gets a title which is from the defects of a particular title of transferor. For example, if a bearer check is transferable by some person after it is stolen by him, the transferee of such stolen check becomes a holder in due course, even though the check is stolen on certain conditions given by the Act. The liability of the negotiable instrument in law is extensive. In the case of check which is dishonored wrongfully by the drawee bankee, or the holder of the check can file a suit against any endorser of the particular check. When a check or a suit is filed against an endorser, the endorser can also file a suit against the drawer, and the drawee in turn can file a suit against the drawee. They are payable either to order or the bearer. And we'll talk about promissory note. A promissory note is an instrument which is writing in unconditional undertaking signed by the maker to pay certain sum of money only to or to the order of a certain person or to the bearer of an instrument. It comes under Section 4 of NI Act. Examples we can say, I promise to pay so and so amount, and I acknowledge myself to be indebted of a 500 rupees to be paid and demand for values received can be taken as an examples. Parties we can see the maker, payee, and the holder. The person who makes, the person who pays. The holder is the person who just hold the particular instrument that comes under Section 8. Characteristics, it should be on a writing. Promise to pay must be expressed, and it should be definite and unconditional. Should be signed by the maker. Certainty in the case of parties, certainty in the case of some money. Promise to pay money only, and formalities are not essential for this. Next, bill of exchange. This bill of exchange comes under the particular act of NI, which is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay certain sum of money only to or to the bearer of a certain person or the particular bearer of an instrument. It should be also in writing so as to oral order cannot be called as a bill. The bill must be addressed to a specific person. The bill must be contained in order to pay money and not a request. The amount shown in the bill must be definite and clear. The date should be in a writing in a clear manner. The duration of the bill must be definite. Parties we can see drawer of the bill, acceptor or the drawer, the payee of the bill, or payee of the particular bill. Three parties will be there. Bill of exchange always stands for drawer, drawee, and the payee, the person who issues, the person whom the bill is issued, and the person to whom the payment has been made. It should be on a written, duly signed by the drawer, drawee, duly stamped, order to pay in terms of money only. The party should be certain, sum payable must be certain, unconditional, and date. And the details of the particular banking sectors will be coming. Bill of exchange should come under amount, date, period, signature, and revenue stamp. Types we can see, bill must be payable immediately on demand or bill at a site, bill payable after the stipulated period or a bill after time. And a specimen we can see like this, so and so person name and the time, date, and at the same time when it was been taken and what will be the order and should be stamped. Differences we can see, the points, bill of exchange and the promissory note, order of the particular promise, who draws on whom, need for an acceptance, and the parties. Coming to the check. A check is also one kind of bill of exchange with the 3 additional qualifications. It should be always a specified banker. It is always payable on demand. It also includes electronic image of a particular check, and also check should be an electronic form. So check is an instrument in writing containing an unconditional order and addressed to the banker signed by the person who has been deposited with the banker, requiring him to pay or demand a certain sum of money only to or to the order of certain person or to the bearer of an instrument. Essentials, if we can say, it should be on a writing. The writing must be paid by pen, typewriter, printing characters, ballpoint, even pencil, without any kind of other materials. So check must be in the form of order and not in the form of check. So order must be unconditional. If any condition is attached with an order, the check will lose its legality. The payment must be made to a certain person, bearer or self, and it must be drawn on a particular banker. Different types we can see: bearer check, order check, uncrossed or open check, crossed check, and antedated checks, post-dated and stale checks. So sometimes a check may be dishonored, and it is said to be dishonored when it has not been paid by the paying banker on the presentation. Circumstances when the check can be dishonored is nothing but the paying banker dishonored the check when it is having an unconditional ones. And at the same time, customer counterpays the payment of any check, the banker must refuse to pay or to make the payments for that check. When the bank receives a note from the holder about the loss of a check, he cannot be ignored that notice and make the payment. And now, holder and the holder in due course. Holder is the person of a negotiable instrument. The person who holds, he should be entitled in his own name, possession of the particular check, and receive or remove of a particular amount due thereon to the parties. Necessities to be hold or a negotiable instrument. It should be entitled on his own name, possession of a particular instruments, and it should be right to recover and amount thereon. So every instrument initially belonging to the particular payee, he can transfer the particular payees, and at the same time it should be coming under the particular activities, and negotiation is possible in the particular cases: order of an instrument, bearer of an instrument. And a person who is legally entitled to receive a money due onto the instrument can be called as a holder. So holder in due course comes under section 9 of NI Act. Any person who for a consideration become the possessor of a NI, if payment to the bearer or the payee or an endorsee thereof, if payable to order, before the particular amount mentioned in the name became payable, and without having sufficient cause to believe that a defect existing in the title of a person from whom he derived his title. So conditions, you can see: he must be a holder of a particular valuable consideration, he must become a holder of an instrument before the date of maturity, he must become the holder of an instrument in good faith, he must not have any reason to believe on the title of instruments to be defective. Parties, we can see: presentment, negotiation, and discharge of a liability. And presentment is nothing but Negotiable Instrument Act comes under a placing of an NI before drawee is called presentment. And this is an authority, a formal statement of a particular matter to be dealt with, specifically the notice taken or statement made by a grand jury, an offence from their own knowledge without a bill of an enactment, an accusation of a wrongdoing laid before them, to whom the presentment can be made, time and place for the presentment, the drawee of the particular bill, the drawee in cases needed, or when the drawee there are more than one drawee, the acceptor or the honor, when the time or a place is been specified, and at the same time when the time is not been specified within the reasonable time, and when a particular presentment is not necessary and any particular time can be taken. Presentment will be made under the particular institutions, like valid presentations can be taken on the property day, proper way, and at the same time at the proper hour, proper person, a place, and at the same time the manner. Negotiations will be taken under the particular way of a process in which two or more parties are exchange of goods and services attempt on the exchange rate for them. A give and take making machines or making process involve independent parties with different references or preferences. So transfer by the negotiation can be contains two conditions. It comes under section 14. It must be transferred of the particular instrument to another, and the transfer must be made in such a manner as to constitute a transfer the holder of an instrument. And discharge of the parties comes under the liability. A negotiable instrument is said to be discharged when all the parties of an actions under the particular are completely extinguished, and at the same time when it ceased to the negotiation. After it is discharged, the right against all parties there to come to an end of a particular party, even a holder in due course can claim the particular amount of an instrument from any party thereto. So different modes of a discharge instruments can be taken: by payment in due course, by express waiver, by cancellation, and by material alteration. So finally I can say bill of exchange therefore is written acknowledgement of the debt written by the creditor and accepted. They are usually three parts of a particular vase, and the drawer and the drawee. Thank you.